To accomplish great things, we must not only act, but also dream, not only plan, but also believe. These are the words of Anatole France, who was a French poet, journalist, and novelist.
A delightful evening to one and all present here. Today, we have all gathered here in this virtual platform for the valedictory session of our 16th International Seminar on the role of international law in controlling weaponization and arms race in outer space, put forward by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research and IQAC KLA to provide a premier interdisciplinary platform for researchers, practitioners, and educators to present and discuss the most recent innovations regarding the need for space dispute settlement mechanism about the relevance of sanctions and enforcement in existing space treaties.
Outer space is a province of all mankind and is to be used for peaceful purposes only. However, at the same time, space has always been a militarized environment. Space, in a way, is a resource, and it is only a matter of time when we looked up in the sky and made up our minds to make the best possible and economical use of this resource. Not only is it in human nature, but it is also economically beneficial for us to explore and exploit lands beyond Earth.
Kerala Law Academy Law College, since its inception into the legal hippodrome in the year 1966 by the legal luminary, late Dr. N. Narayan Nair Sir, has always been seat of excellence in legal education, consultancy, research, and pioneering law reforms. Through its various programs and events of international and national significance, Kerala Law Academy consistently aspires to push boundaries and is in its constant effort to provide the most stimulating environment for its students to cultivate and showcase their greatest abilities.
Before we begin our valedictory section to this cosmic event, let's spend a minute in silence to cherish the memory of our beloved Dr. N. Narayan Nair Sir, who has always been an inspiration for all our ventures. Thank you all.
Leaders instill in people a hope for success and a belief in themselves. Positive leaders empower people to accomplish their goals. Today, we have with us Professor Harindran K. Sir, Principal, Kerala Law Academy, a man with a charismatic personality and extreme energy, who's the guiding light of wisdom for the students of Kerala Law Academy Law College. From the bottom of my heart, I invite Professor Harindran K. Sir to officially welcome our guest into this valedictory session. Sir, please.
We are facing some technical issues. I request everyone to please wait.
Yes, I am audible.
Yes, sir, you're audible.
Okay. Thank you, Vaishnavi Nagaraj, for your kind and nice words. Okay. At the outset, we are paying our tribute and homage to our beloved founder director, our leading and guiding lamb, Dr. N. Narayan Nair Sir. Now we are moving to the valedictory session of the 16th International Seminar. Most respected G. Levin Sir, most respected Advocate Ashok GV, Most respected Advocate Nagaraj Narayanan sir, our director. Most respected Professor K. Anil Kumar sir, our director. Shakti Prabha M. Assistant Professor. My friend Professor Anil Kumar G, Vice Principal of this institution. Professor Ajda Nair L, Senior Faculty Member. Dr. Dakshina Saraswati, and other distinguished invitees, resource persons, participants, faculty members, students, parents, non-teaching administrative and technical staff, and also all the well-wishers of this college. As you know, we have virtually joined here to take part in the valedictory session of the 16th International Seminar on the topic Role of International Law in Controlling Weaponization and Arms Race in Outer Space, hosted by Kerala Law Academy Law College in association with the Center for Advanced Legal Studies and Research Center and Internal Quality Assurance Cell IQAC. Today, we are immensely blessed with the august presence of G. Levin sir. He is a VSSC scientist, satellite developer, and space expert. He joined the ISRO in 1983. He has been appointed as the new director of the Space Park, and his appointment comes as a part of the revival of space exploration and research activities in the state of Kerala. He formerly held the positions of Division Head Group Director and Deputy Director of VSSC. He was a recipient of ISRO Team Excellence Awards for PSLV development in 2008. Besides this, he has been awarded the Dalmia Hemsey Award in 2017 for outstanding contributions in the field of solid propulsion for space vehicles. He will deliver the valedictory address here. Sir, we are eagerly waiting for your valuable words. On behalf of Kerala Law Academy Law College, Culture and IQAC, we extend a profound and profuse welcome to you, sir. Advocate Ashok GV. He is an advocate and a partner at Factum Law. He is a technology lawyer and a resolution counsel. Being a technology lawyer, he has represented his clients in a variety of disputes involving tax, intellectual property, labor, and contract law in conventional and alternative dispute resolution forums. He is a very keen interest in research, publication, and teaching, and hence has written, published, and delivered texts in international and domestic journals and fora, including law schools, engineering colleges, judicial academies, police training centers, conferences, and seminars on subjects ranging from criminal investigations, health and pharmaceutical regulations, technology reforms in the justice system, constitution, space law, etc., etc. On behalf of everyone present here, we welcome you, sir, to this function. Advocate Nagaraj Narayanan, sir, our director and special government pleader, Forest High Court of Kerala, member of Bar Council of Kerala. He is very dynamic, energetic, and a man of positive attitude and new ideas. We acknowledge the guidance, effort, and support of Advocate Nagaraj Narayanan, sir, for conducting this international seminar here. It is indeed my pleasure to invite and warmly welcome Advocate Nagaraj Narayanan, sir, to this function. Professor K. Anil Kumar, sir, our Director, Administration, Faculty, and Student Affairs. He is a constant source of support, inspiration, and motivation. He is very enthusiastic and very active and efficient in conducting not only this program and all programs which already we conducted so far here. I sincerely and cordially welcome Professor K. Anil Kumar sir to this function. Professor Anil Kumar ji, my friend, Vice Principal of this institution, he is a senior faculty member having more than 25 years of excellent experience in teaching profession. We extend a warm welcome to you, sir, here. Shakti Prabhayam, I welcome Sri Shakti Prabhayam, sir, Assistant Professor, Kerala Law Academy, Law College, and one of the faculty conveners of this event, who will also be rendering the vote of thanks to this section. I extend a warm welcome to you, sir. I take this opportunity to welcome the faculty conveners, Professor Ajita Nair, a senior faculty member, Dr. Dakshina Saraswati, Srimati Sharin Elsa John, Advocate Arya Sunil Paul, Sri Sajit Sangaranarayana, yes, and also the student conveners, Arya M.A., Roshni, yes, Lakshmi Ramesh, Mekha M.L., Navami R.S., Namita Babu Benedict, and the student moderators, Vaishnavi Nagaraj and Arya S., who are presently anchoring a gentle and classical manner in this function. Last but not least, I would like to welcome all other distinguished invitees, resource persons, participants, faculty members, students, parents, non-teaching, administrative and technical staffs, and also all the well-wishers of this college. Thank you. Thank you once again.
Thank you, sir, for your warm welcome. I take this opportunity to welcome you too into this ceremony, sir. Now, we have the presence of G. Levin, sir, CEO and Director of K-Space and former Deputy Director of VSSC. He was a profound satellite developer who played a major role in the PSLV and GSLV project of India and a very enthusiastic space expert. He joined the ISRO in 1983 and has now become a part of the revival of space exploration and research activities under the state of Kerala. It is an honor and privilege to have such a distinguished personality on this occasion. With immense pleasure, I invite G. Levin, sir, to give the valedictory address. Sir, please.
Good evening, everybody. Professor Harindran, Principal of Law Academy, for that nice introduction and welcome. And all the other dignitaries attending this program virtually. All the participants, good evening once again. It's a very difficult affair to conduct the valedictory function of any seminar or conference. My own experience, getting people for the valedictory function at a seminar hall, it is extremely difficult. And managing 200 plus participants attending this valedictory function is a great thing. It says about your organization capability and the standard follow-up the organizing team has done to ensure the maximum participation. Second part of the difficulty is getting the speakers for the valedictory function. Most of the eminent speakers would have packed up and maybe traveling back by the time you start the valedictory function. And what we used to do earlier days is get the most convenient person at your vicinity who will be always available to take up that responsibility. Maybe virtual mode of conferences has helped you to identify eminent people for the occasion. And at the outset, I want to say that two things. One correction to Arya regarding the introduction about me. I am not a satellite expert. I am the responsible mainly for the launch vehicle or the rocket part. Okay, and in that area also, specifically for the solid propulsion, though I will be knowing certain aspects of the other elements, including satellite. Okay, I think with that introduction, let me we can start the discussion, and maybe you can ask any questions during the discussion or at the end of the discussion. First of all, I want to appreciate the title of the conference, the role of international law in controlling weaponization and arms race in the outer space. It is a very timely subject to be worried about by the law fraternity, and that is mainly because if you follow the space activities happening across the globe, lot of new activities are happening. Okay, and first and foremost is the entry in a big way of the private entrepreneurs into the space sector, led by Elon Musk. And in fact, I should compliment him. Now he has taken the space activities to a much higher level of activities compared to the earlier years. And what the space communities have achieved in the last 50 years, I think he has achieved and surpassed it beyond limit now within this short time of less than 10 years. That is a type of innovation is brought into the space activity. Now the number of activities, space activities are also going up. Number of launches increased manifold, and number of satellites being injected into orbit also gone up in numbers. Okay, and basically the number of satellite increases mainly because of the Starlink project, where he is trying to offer telecommunication services from orbit directly to the customers. And he has already pumped in over 12,000 satellite into low Earth orbit. The next batch is going to be 22,000. So that is a type of mass injection of satellite into the low Earth orbit happening. And he is followed by OneWeb and other constellations across the globe by Chinese and Russian space agencies. So that is one part of the activity. The second part of the activity is related to the space tourism related ventures. Okay, I think you all heard about the space tourism ventures already initiated by Blue Origin, and SpaceX is going to follow it up with another great initiative of Starship. So it is all going to be very exciting. And he has also announced the America is going to set up a permanent space station or a space research station in the moon. And Elon Musk is targeting for a mass colonization by 2030. So it's all going to be very, very exciting and very complex and challenging. And if you follow the human history, we started our war the day we are born in the earth. The history of us dated back to the history of humankind itself. The day we started living in this planet, we started fighting. And early fighting we did mainly at the ground. And the people with muscle power and manpower to conquer the boundaries around their countries. They have developed their countries and built empires. Okay. Then it followed the next phase of activity where the naval power got into picture. Naval power, it has given the opportunity for people to move across the globe to different continents far away from their native country and set up colonies across the globe. So people with the maximum naval power have gone across the globe and landed in spaces, remote spaces like India, and India has become a colony of Britain. So that was the second phase of war in which the naval power gained the supremacy. The third phase was the aerial or the aircraft getting into the picture, and the people with the maximum air power started ruling. That's why America became the superpower during the World War II. So that was the three important phases of war and weaponization related to the war. Now, the third phase was the space arena. The space has given another opportunities for people to fight. So that is the developmental part, and the benefits of what we draw, it is one part. The second part is the same community who got into the space started seeing it as an opportunity for weaponization and gaining the control over other countries across the globe. So that is the era of space, and the space-based satellite for the remote sensing. You all know it has been doing the dual role of observing the Earth and gathering the data and providing it for the societal applications. And one part. The second part is the strategic application of the same data. Or in nutshell, the strategic data part is collected is of more precise and accurate to enable the countries to target their enemy stations more precisely. That has given an advantage, and you may be hearing about the Indian complaint, that is during the Kargil war. We wanted to have the GPS data of the area to identify the locations in which the enemy army people were getting crowded. We wanted to target them very precisely. But unfortunately, the control was with US, and they are not willing to share that data. What we have done, we have gone for our own Mavic, which will offer almost equal services precisely for India. That means we are into the arming of the outer space for the application. One side for the societal application, second part is to base the getting an upper hand over our enemies sitting around. So that is happening across the globe. And another aspect of the what you heard is regarding the destruction of a satellite by countries, because America started with that experiment. In orbit, the satellites are keeping a definite path and orbit. And to me, it is a soft target for anybody to target and kill. So that is the advantage for an enemy to attack any satellite. So that way, America started the experiment, and they have mastered the technique. Russia followed, and then came China. And I think a few years back, you would have heard about India doing the same experiment in orbit to kill our own satellite for the experimental purpose to demonstrate the capability. We can also do. I think it doesn't require much of thinking, because once you identify the target, it is easy. You have to simply position your satellite in line with the enemy satellite, and either you go and hit that fellow, so that it will break into pieces and get distributed. Otherwise, you send a projectile so that it can kill. Otherwise, you send a small explosive so that it will get busted. So this is all capabilities. I don't know how we will all circumvent these issues. Now the next phase has come. I think next phase is, so far whatever I told is reaching only the orbit or the outer space. Now we are seeing the occupation of spaces beyond the Earth orbit. We are talking about the moon research station. Okay. So any research, it will have a positive and a negative aspect of it. And we will all clap for the positive gains it is going to give us. So basically, we would like to know about moon. What is it comprised of? Whether there is any possibility of getting some of those precious minerals or resources out of moon, or it can be used as a launch pad for going to still outer other orbits or other satellites or beyond Mars or even other stations. So even we can, from the solar system, we can go to the next level. Okay, that may be the ministerial part of it, but I don't know what will happen. The same station doing some research and development, or the station being used for the weaponization and targeting the enemies. The enemies are now spread beyond the Earth. Their enemies are not in Earth alone. It is going beyond Earth. And many of their objects or research stations are put in the space. Maybe the permanent stations or the orbited platforms which are operating, or the costly satellites, we can be all targeted. But beyond that, certain more aspects can be planned and executed. But for the public, what the statement will be, all the positive research aspects, what can be done in moon. Okay. But beyond that, what exactly they are framing up, we don't know. Maybe after some time we'll know. And the Mars mission, okay, it is having a positive plan of making a human colony there to create a artificial environment for people to live in there for a longer duration. That is the stated objective. But that is the objective by a civilian entrepreneur, Elon Musk. And I don't know what way the new developments will happen beyond this stated plan. So what is going to happen for the future? It is very, very challenging. And definitely the law of fraternity definitely they have to worry about what way we can put some sort of a framework agreement among the spacefaring nations now itself, and have some sort of a control. I think that is the most appropriate time to do that sort of a study and propose some meaningful arrangement by which we can bind everybody in the business into some sort of a action plan. So that is essentially required, and otherwise it is going to be extremely difficult to survive. So one thing I want to say that, like the human tendency is, if you are reaching a ground in the beginning, and it is going to be something of attractive place, you will try to occupy the maximum. So that is a general human trend. And that's what happened in the GTO orbital slot allotment happened in the early years. The American and Russian satellites reached or attained the capability to launch satellites in the orbit. And what they've done, and they have almost monopolized the precious GTO orbit, GS orbit, geostationary orbit. Why? Because it is at 36,000 kilometers above the equator. And that is the only slot in which the satellite will maintain the synchronization with the ground. So that is the most preferred location for the satellites for the communication application. But what the American and Russian team has done is they have almost monopolized the area, the available precious orbit, and made an arrangement in which the other countries and other smaller countries, including Russia, including India, we are provided with a smaller slot allocation based on the activity level happening during this early 60s and 70s. So whoever going there will have some sort of advantage, and India as a country should not fall behind. And that is the way we can make progress and make. May I take 1 second break? Okay, I think my boss was calling for the IT secretary for an important discussion. Okay. Okay, what you are telling us just to have the early bird advantage of reaching to the newer stations as early as possible, and we should not fall lag far behind compared to the early birds. And we should be one of those early birds to get or take advantage of that advantage. Okay, I think we are also gaining our muscle power, and you all know we have reached to the global leadership position in a very difficult way, and we are one of the major economic powers. That muscle power is mainly due to the economic power given by the technological growth of the country. There, the space sector also played a meaningful role. And while telling about that, and we have to maintain some sort of a order in the outer space. And it is a really challenging task because none of these leadership teams are going to give away their advantage so easily. But at the same time, for the overall benefit of the human species, we should bring some of those framework in position as early as possible. And we also have to be very cautious about the geopolitical scenario now. We had a bipolar framework until recently, till the Soviet Union break down. And subsequently, we had the unipolar universal framework in which US was dictating on every aspect. But today we are in a changed scenario in which the China has come up as a big major power to be reckoned with, and they are almost challenging the American supremacy. So that is the one scenario, and the later the Russian-Ukraine war. That is also giving another lesson for everybody. I think the lesson is the Russian supremacy or the military power. It is being challenged. But Russia joining China, it will be a major challenge. And at the same time, the other countries, including the countries like North Korea and Iran, attaining the space capability, that is also going to be another major challenge for the global peace and the survival of the population. So it is going to be a very challenging time, and I feel for the outer space weaponization, definitely some early action is to be taken up immediately. Maybe the time frame also we have to put in now itself, because it should be done before the so-called research lab is getting materialized in moon, as well as before the colonization starts for the Mars. And we don't know what sort of challenges will be thrown by the coming years by the enterprising new entrepreneurs who come into the picture, or not controlled by directly under the control of the government institutions. So these are all the facts to be understood, and the legal fraternity definitely they have a role to play, and it is the most appropriate time for us to sit back and do this exercise and convince the global community for the need and essentiality of such a legal framework to control the arms race in the outer space in the days to come. So I wish the organizing team and Law Academy and all the participants yeah, great time ahead and wish you all the success. Thank you very much.
I extend my heartfelt thanks to you, sir, for your valuable words that filled us with the awe and joy of your wisdom. We are truly enlightened. Thank you so much, sir.
Thank
now,
you. Thank you.
Now, we have the presence of Advocate Ashok GV, technology lawyer and partner of Actum Law. Owing to a keen interest in research, publication, and teaching, he has written, published, and delivered various talks in international and domestic journals and fora, including law schools, judicial academies, conferences, and seminars, ranging from technology reforms in the justice system, constitution, space law, and many more. I invite Advocate Ashok GV, sir, to the special occasion to give a special address. Sir, please.
Thank you. So, very good evening to one and all. I think one of the challenges I'll have as a speaker in the valedictory session is what do I say that's not already been said before? And I'm going to try and, hopefully cover some subjects that I don't think has been touched upon earlier in this event, in the hope that we can have a picture of where I'm coming from and what is the kind of interest area that I represent. So to give a little background, the theme of the event being largely space law, at the outset, I can say that people who are far more qualified and knowledgeable on the subject have already spoken. My specific presence here is essentially to represent the voice of a private sector economy in space, because the last couple of years and decades has seen the emergence of a new actor in space, which is the private sector. When the Outer Space Treaty emerged, and so did all the other collateral sources of treaty law on space, what was not contemplated was the significant role that non-governmental organizations will have in terms of how humankind will reach the stars and beyond. Right? But what we have seen, as was already covered in the previous talk as well, is that you do have entrepreneurs coming up in a big way. And what are the concerns that they represent, and what are the kind of vulnerabilities that are perceived by the private sector when we talk about things like weaponization of space? And I think that's what I would like to cover in my brief discussion, which I don't think should be more than 15-20 minutes. Let's take two specific case studies, right? The first case study is the Russia-Ukraine conflict. For those of us who followed the conflict, what emerged is that one of the initial signals that the conflict was starting was in the form of a private sector satellite, which was actually providing communication services to Ukraine military forces. That was knocked out by what is widely believed to be Russian hackers. Now, this raises significant questions under international law, right? So, for example, if a satellite which belongs to a civilian organization or a non-governmental organization or a private company is actually servicing a military customer, either in terms of addressing their communication requirements or addressing, say, Earth observation requirements, mapping out, border positions, bunker positions, and providing related data, is it fair and legitimate for the opposite side in the conflict to employ either kinetic or non-kinetic means to knock out the satellite? Now, this question has become increasingly relevant in the recent past, especially because, of course, of how satellites have been targeted. Number two, because space is now considered to be another domain or theater of warfare. So this question has to be asked, but the answer is supremely complicated. Let's go, for example, to the subject of international humanitarian law, or the law of armed conflict, as we call it. Now, what humanitarian law stipulates in a situation like this, especially based on some of the case laws that emerged in the context of Bosnia and Yugoslavian conflict, is that if you stick to the principles of proportionality, neutrality, take steps to mitigate the effect of your strike against the civilian target, then chances are that you could still be justified if you can show that the civilian asset was used to further military hostilities. So, to summarily put it, the concept of international humanitarian law says if the civilian asset is used by a military force or used to advance the cause of military conflict, you are within your right to target it, provided, of course, you take steps to mitigate the damage and ensure that it's proportional, so on and so forth. Now, the moment you take this school of thought and apply it to the context of, say, a target on a satellite in orbit, then the legal position becomes complicated, because any kind of damage occurring to a space object in space, there is fault-based liability for the person causing the damage, right? And if you look at the definition of launching state in the liability convention, it is so broad that leave alone the person who's operating the satellite, but even the owner of a payload within the satellite could potentially be held liable if that satellite or the payload causes damage to somebody else. Right? Now, if, for example, an inspector satellite is used to knock out another satellite which is employed in the military hostilities, the question that arises is, will international humanitarian law come to the aid of the aggressor and give him immunity from potential liability under international space law? Or will international space law prevail and impose liability on the aggressor who has decided to target the satellite? And if you study the scholarly opinion on the subject, it is broadly divided, but there is no clarity as to which school of thought will prevail. Will it be the school of thought under IHL, or will it be the school of thought under international space law? Now, this has profound questions for the private sector itself, because if I do not know what is the kind of legal liability that I can potentially look to enforce if my satellite is targeted, I do not know how safe my satellite is in the context of a orbital slot, right? What then does it do to the concept of keeping space free of weaponization and conflict? So what we need to understand is that conflict is essentially synonymous with a lack of a clear, enforceable legal regime. The moment there is clear, enforceable legal regime, chances are that state parties need not resort to military hostilities. But the moment that kind of clarity is not there, the moment that kind of enforceability is not there, then chances are that military hostilities becomes increasingly an option on the table. Right? And what this does to a satellite operator in the 21st century, I will discuss that in the days to come. But this is just one example of how lack of clarity in the international legal position has created so many questions for the private sector enterprises as well as the investors looking to invest in this economy. Let's look at another example: attribution of state responsibility for cyber attacks. Right? Again, if you look at the current scholarly work on the subject, it is so difficult to make a state responsible for a cyber attack conducted by a non-state actor having the nationality of the state actor. So one big example and one big elephant in the room on the subject is always North Korea. North Korea is known to foster and encourage cyber attacks by non-state actors, of course, acting under the mandate of North Korea. This ranges from theft of money online to a whole bunch of other things. One of the best examples you can remember is the cyber attack on Sony offices right after a movie came out, which kind of depicted a humorous interview of the North Korean dictator. So in a situation like this, to say that it is North Korea that has to be held responsible under international law is extremely difficult, simply because of how high the burden of proof is and how easy it is to evade that burden of proof by masking the signature of the cyber attack. But again, the moment you take this example to, say, a cyber attack on a satellite, more fundamental questions begin to get asked. If we want to call it a space activity and then say the state is responsible under Article 6 of the Outer Space Treaty, what is the burden of proof that you have to meet? Number two, does a virus that is uploaded onto the satellite from a ground even qualify as a space activity or not, so as to bring the Outer Space Treaty into operation, right? And with all that said and done, if you're able to show that it is a space activity, which I think it is, then the question arises, how does the state really ward off the application of Article 6 of the Outer Space Treaty, whereby it becomes responsible internationally for the actions of its non-state actor? Right? Now, there are certain principles of state responsibility that could help. For example, the substantial reliance principle, which is that if significant infrastructure is needed to mount the attack and that infrastructure has been provided for by a state, then chances are that the non-state actor relying upon that infrastructure can still be held to act on behalf of the state themselves. So the other thing is guilt by omission. If you haven't taken sufficient steps to prevent the breach of international obligation from your soil, then you could be held internationally responsible. These are certain principles under conventional laws of state responsibility, which we are now having to examine as to how to apply in the context of, say, a cyber attack on a satellite asset. Now, will international space law prevail? Will Article 6 of the Outer Space Treaty make the state responsible for the cyber attack when otherwise it is not? Again, there is no clarity on some of these questions. But what it does is that it provides a certain degree of plausible deniability, so to say. Because tomorrow, if I am in a conflict with another country and I decide that I want to knock out the satellite of the enemy country so as to disrupt their communications, for me, space is a very tempting theater of warfare for the simple reason that the legal position is unclear, as opposed to conflict on the ground. If it was targeting on the ground, I have enough case laws, I have enough jurisprudence, I know exactly what is okay and what is not okay. But if I have to target an asset in space, so much of it is the Wild West. I don't know which school of thought will prevail, and therefore it gives me a lot of incentive to undertake activities for targeting satellites in space, because the concept of me being legally liable is that much lesser. Now, this is exactly the kind of atmosphere that enables nation states to get into an atmosphere of military hostilities. So if you go back to the time of history, and it was so well put by my previous speaker, most of the conflict between the big powers, be it England or France or Spain, happened under the guise of trade missions having to assert their rights over newly found colonies. Right? What started off as a trade charter for the Christopher Columbus or Vasco da Gama or the English East India Company eventually became sources of conflict between the English and the French in the United States of America. It became the source of conflict between Tipu Sultan and the British in the south, with the French supporting Tipu Sultan. So you will notice that there's a history of unclear legal principles governing the discovery of new areas under the guise of trade interests, resulting in military hostilities. And that is the reason why we have to really examine the need for clarity in international space law. Now, clarity can mean two things, right? Clarity can either mean that we need new treaties, because for whatever reason, Outer Space Treaty is not sufficient, which I beg to disagree with. Or we could argue that what we need is a greater understanding of what is already stated in the principles of existing treaties, be it the Outer Space Treaty or the Liability Convention. Now, this is precisely the role that legal professionals will have to increasingly play when it comes to this particular domain. One example of rulemaking through interpretation, which I think will likely emerge in the days to come, is this very convenient use case of the Artemis Accords. Because though it is not a treaty, though it really does not claim to create a source of law, it essentially subscribes to a particular way of reading and interpreting the Outer Space Treaty. And if sufficient number of states are signing up to that view of the Outer Space Treaty, could it potentially then be construed as state practice? And therefore, later on, construed to hold a variety of things relevant to the private sector, including the right to mine resources on the moon and beyond. So we have to really ask ourselves whether we want rulemaking for the 21st century in space to emerge through the channels as surreptitious and as subtle as the Artemis Accords, or do we want there to be a more robust, a more clear, a more less disputable binding set of frameworks on space activities? And that becomes very, very important for the private sector. Because today, for example, I don't know what is the definition of a weapon in space. Russian Inspector satellites are a great example. Do they qualify as a weapon in space or do I qualify as a satellite in space? I don't know, have the legal answer to that question. Now, the difficulty arising out of that is if tomorrow the Inspector satellite manages to take down a satellite belonging to, say, a Viasat being used by the Ukrainian military forces, the question is it simply a case of collision in space covered by the International Liability Convention? Or does it then become a military strike so as to provide Russia immunity under international humanitarian law? So the need for clarity on this becomes absolutely critical. We need clarity on the precise extent of ownership rights over what is discovered in outer space. I know we have a very nice outer space treaty that seems to suggest that ownership is not possible, but countries like the United States and the language of the Artemis Accord seems to say that that is not entirely undisputed. And if ownership rights are not equitable, if ownership rights are not properly distributed among the nation states, between the developed economies, between the developing economies, chances are that you are essentially laying the seeds of a future conflict, right? Because inequitable distribution of either technology or the means to mine the next generation of precious resources historically is always responsible for countries colonizing one another and resulting in conflict, right? When we have clear set of principles of law, what it makes is the activity becomes predictable. And if it is predictable, chances are that you are able to attract capital to a particular activity or industry. Now, there are two ways of looking at this. Increased capital into the space industry means more trade in space, therefore less conflict, or more trade in space means more conflict, because obviously everybody wants to assert their right over trade. Right? So we need to really start looking at the microscopic impact of how some of these lack of clarity in laws is really affecting the people on the ground, right? And last but not the least, and this is so important, if you don't have means of enforcing what is claimed to be the legal position, then what is the point of having the law to begin with? So you could, for example, tomorrow take a view that I will not allow for resource mining in moon. But if somebody is doing it and you don't have weapons on the moon to stop them from doing it, then what's the point of doing it? Right? So I'm not saying that we need a space police force, but what I'm saying is that we need dispute resolution mechanisms on the ground. Like, for example, the space court that is set up by the Dubai International Financial Center court. So a court of law or an arbitration forum that can specifically examine and address some of these disputes so that the parties need not resort to taking the law into their own hands. And I think this becomes very, very critical to build transparency and therefore build trust. Right? Now, let's come to the problem statement for lawyers like me, right? Because we are not the people who are publishing in journals abroad or domestically. We are not the ones who are publishing things like the Italian manual. We have to take what is already published and explain to our clients what they can and cannot do. Now, take, for example, the case of Viasat and the Ukrainian military customer. If Viasat's contract with the Ukrainian military customer says that Ukrainian military is exempted from any and all obligations under the contract if there is an act of force majeure coming in the way of the performance, and Viasat also does the same, what does it do to the indemnity that a military customer provides to the satellite provider, saying that if your satellite is damaged because of the work you're doing for me, I will then indemnify you? Because the moment that indemnity is invoked, the customer can very well go back and say, look, war is force majeure. I am not in a position to take accountability or provide damages for what essentially is a force majeure event. Right? So how are you defining force majeure event in a commercial contract for satellites providing services to military customers? You have to fundamentally rethink this entire clause as a commercial lawyer. You may have a great insurance policy that says that my satellite is insured, but does the insurance policy also contain a clause that says that damage caused during hostilities will not be covered by the insurance scheme, right? Or does it say that, look, the moment you decide to work with a military customer, we will assume that it is a high-risk activity akin to an adventure sports activity for health insurance, and therefore say we will not cover the liability that follows. So are your insurance contracts being properly negotiated? Have you ensured that you have indemnities when you decide to work with military customers and state customers so that you do not become a target in military conflict? And if you're not able to invoke the International Liability Convention against the aggressor, can you at least go back to your customer and say that, look, I've taken a bullet for you. Would you come and compensate me now for the losses? Right? How does your contract really address that? And going back to the substantial reliance principle of attribution and state responsibility, what are the safeguards being built in India's telecom laws and telecom laws across so that licensing is being done with the requisite level of due diligence so that tomorrow somebody does not employ my fiber optic network, my uplink capabilities as a nation, only to upload a virus onto a satellite belonging to a foreign country and a foreign hostility. So are there sufficient safeguards in our licensing regimes? So a big part of the work that we have to do as lawyers is not to complain that there is no clarity in international law, but to essentially see where there is clarity and see how we can take that clarity and then impact the work we do with our clients. And if you're not able to make that effort, then essentially no amount of clarity in international space law will make a difference. Is there a need for clarity? Yes, definitely. But it's not, the clarity is not going to be found in the future exercise of formulating a new treaty. The clarity has to be found by constructing jurisprudence from existing sources of international law, which is precisely where I come to my last point, that legal professionals today cannot come and say that, hey, space law looks very glamorous. I'm going to only do space law and nothing else. You can't do space law if your fundamentals in other areas of law like jurisprudence, interpretation of treaties, international law, state responsibility, right? Things that we take for granted. Otherwise, if you're not going to take those concepts seriously, you can't do justice to your client as a space lawyer, right? That brings me to the end of my session. Thank you very much. Any questions? I'm happy to take it up now.
Thank you, Ashok sir, for your valuable words. We are indeed blessed with your knowledge. Gratitude is a powerful catalyst for happiness. It's a spark that lights a fire of joy in your soul, says Amy Collett. Now, I welcome Sri Shakti Prabhayam sir, Assistant Professor, Kerala Law Academy Law College, and one of the faculty conveners of this 16th International Seminar to give the vote of thanks. Sir, please.
Thank you, Vaishnavi and Arya. Greetings to one and all. Most respected Sri G. Levin sir, CEO K-Space, Kerala Space Parks, former Deputy Director VSSC ISRO, Department of Space, Advocate Ashok GV, Advocate and Partner Factum Law, Advocate Nagaraj Narayanan sir, Director Kerala Law Academy, Professor K. Anilkumar K. sir, Director Students and Faculty Affairs KLA, Professor Harindran K. sir, Principal KLA, Professor G. Anilkumar sir, Vice Principal KLA, Professor Ajita Narayan ma'am, Senior Faculty KLA, and other distinguished invitees, my colleagues and dear students. I consider this as an absolute privilege to present the vote of thanks in the valedictory session of the 16th International Seminar on this topic, the role of international law in controlling weaponization and arms race in outer space, organized by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research, CULSAR, and IQSC, KLA. This seminar aims to focus on the outer space, the common heritage, and laws relating to its control and administration regarding the need for space dispute settlement mechanism and the relevance of sanctions and enforcement in existing space treaties. I would like to first express my heartfelt gratitude to late Dr. Narayanan sir, founder Kerala Law Academy, who always remains as an inspiration for us in conducting these events. Now, I express my heartfelt thanks to Sri Levin sir, CEO K-Space, Kerala Space Park, former Deputy Director VSSC ISRO Department of Space. Sir is a VSSC scientist and a space expert. He's also a director of Space Park, and his deep insights of space exploration he has and research activities under the aegis of Government of Kerala. On my behalf and on behalf of Kerala Law Academy Law College, I extend a hearty gratitude to you, sir. I would like to thank Advocate Ashok GV sir, advocate and partner at Factum Law, being a technology lawyer. He has represented his clients in a variety of disputes involving tax, intellectual property, real estate, labor, and contract law in conventional and alternative dispute resolution forums. Hearty thanks to you, sir, for sparing the time to be with us today and helping us to make this event a grand success. I am deeply privileged to thank our resource persons for the event. Firstly, I would like to thank Professor Dr. Ricky J. Lee, Intellectual Forum Senior Research Associate, Jesus College, University of Cambridge, Executive Director and International Academy of Space Law and Policy, Adjunct Professor of Law, University of Notre Dame, Australia, Adjunct Professor of International Law, Nirma University. Dr. E. Prema, Assistant Dean Law and Assistant Professor, VIT School of Law, VIT Chennai Campus. Sri Aditya A. Variath, Assistant Professor of Law and Coordinator, Center for Research in Airspace Law, NLU, Mumbai. Dr. Rahul Mishra, Associate Professor and Head, Legal Services Clinic, Manipal Law School, Manipal Academy of Higher Education, Bangalore. Professor Dr. Eliga Sade, Aerospace Professional, Consultant, Professor and Educator, CEO and Founder of Astro Consulting International LLC and non-profit Astropolitics Institute, Chief Editor of the academic journal Astropolitics. With utmost respect, I would like to extend my gratitude to Advocate Nagaraj Narayanan sir, Director, Kerala Law Academy Law College and Member, Bar Council of Kerala. He has always supported every activity in this college and has encouraged us to do our best. We are indebted to you, sir, for being the pillar of our strength and giving us courage. I take this opportunity to thank Professor K. Anilkumar sir, Director, Administration, Students and Faculty Affairs, Kerala Law Academy Law College. He's a brilliant academician with years of experience in the field of legal education. I express my genuine vote of thanks to you, sir, for being the pillar of support. Professor Harindran K. sir, our principal, is always a source of inspiration to all the academic activities in this college. He always extends his support and guidance to all the competitions, conferences, international seminars, workshops organized by this college. On behalf of Kerala Law Academy, teachers, students, and non-teaching members, and on my own behalf, I propose a sincere thanks to Sri Harindran sir from the bottom of my heart. I also take this opportunity to express my immense gratitude to Professor G. Anilkumar sir, Vice Principal KLA, for his immense support throughout the event. I would like to extend my heartfelt thanks to our senior faculty, Professor Ajita Nair L. Ma'am, Professor KLA, and we have also been fortunate enough to be backed by a team of dedicated faculty conveners, Dr. Dakshina Saraswati Ma'am. She's the General Secretary, MCS, and Assistant Professor of Kerala Law Academy. Srimati Seren Elsa John Ma'am, Assistant Professor and also Faculty Coordinator of this event. Sri Sajit Shankaranarayanan, Assistant Professor KLA, Dr. Meenu Mohan Ma'am, Dr. Malavika J. Ma'am, Srimati Priya MK Ma'am, Assistant Professors of this institute, and all other faculties for this august presence in this session. I also express my immense gratitude to our IT team, office staff, technical and administrative staff, student conveners, and anchoring team for their tireless effort for the success of this event. Last but not the least, I would like to extend my gratitude to all of you for your kind cooperation and patience throughout the session. Thank you, everyone.
Thank you, sir, for expressing your heartfelt vote of thanks to this valedictory session. As we conclude this seminar, let us remember that the mysteries of the universe continue to unfold, beckoning us to push the limits of our understanding. May our shared knowledge inspire us to reach for the stars and forge a future where the wonders of space are within the grasp of all humanity. On this note, let's conclude this remarkable and knowledgeable valedictory session. On behalf of our institution, we sincerely thank all the dignitaries for joining and enlightening us with their enthusiastic remarks.
I also share my heartfelt gratitude to each and every person who participated in this session for rendering their wholehearted support, which led to the success of this international seminar. And none of this could have been possible without some super-spirited people behind the curtains. Thus, I would like to congratulate and thank each one of them for making our valedictory session a grand success. I use this opportunity to express my sincere gratitude towards Advocate Nagaraj Narayanan sir, Director, Kerala Law Academy, Professor K. Anilkumar sir, Director, Administration, Students and Faculty Affairs, Kerala Law Academy, and Professor Harindran K. sir, Principal, Kerala Law Academy, for providing us with a wonderful platform. I sincerely thank our faculty conveners for their unending support, and I would also like to thank our student conveners for their tireless efforts towards the success of this event. Last but not least, I also extend my heartfelt thanks to all of you for your kind cooperation and patience.
This is Vaishnavi Nagaraj
And Arya S.
signing off.
Once again, thank you all.